Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Brandy Thompson from the Kronzek firm, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law. Today's episode, we're going to talk about legal custody cases, police reform bills, and the no-fault auto legislation that went into effect on July 2nd, 2021. Stay tuned.
In the name of criminal defense.
Recently, Republican and Democrat senators in Michigan introduced a 12-bill package that addresses some of Michigan's most urgent law enforcement challenges, making sure police officers receive adequate training, addressing police officers who are not adhering to proper standards, and making police departments more transparent and responsive to the citizens they serve. We're going to talk about these police reforms with criminal defense attorneys Takura Nyamfukudza and Mary Chartier of Chartier Nyamfukudza. Now, one of the bills would designate tampering with a body camera or deactivating a camera to interfere with an investigation as evidence of tampering. Mary Takura, why is this important?
Well, the George Floyd case, may he rest in peace, shows the importance of filming. The initial press release said that George Floyd suffered medical distress. And that video, which I think no matter how many times you saw it, never became easy to watch, showed that actually was not the case. And even knowing that they had these cameras on that were working and that people would see for multiple views, these officers were just so brazen. Anyhow, the reports came out how they did initially, and thank goodness there were people who captured it on film.
The importance of audio and video just cannot be overstated, as Takura said. Without the video, that narrative of medical distress would have carried on. We never would have known what really happened. And we've had cases over and over again where you read the report and you think, okay, this looks pretty bad for the client. And then you actually see the video and it's totally different. We had one where the police did the stop and they said a headlight was out. And then when we got the video, both headlights were working just perfectly. Takura, you had that one where the client, the resisting and obstructing, right?
Right. So a place not far from where I'm sitting right now, as I'm reading the report, I thought, oh my days, this is going to be quite challenging. And the client, who, although he may have had a drink or two, was still lucid enough to ask for the officer's help. He said, may I please hold your hand while I make my way down the stairs? And if you watch the video, it's almost like it was two completely separate cases because it simply did not match up. He was much more respectful than the report made him seem to be. So completely different, light and day.
It's almost like,
go ahead, Lisa.
Well, it's almost like the video is another eyewitness, but without the fallibility of human, memory.
Right. And video is, it keeps what it's supposed to do is make sure again that everybody's on the same page and knowing what's happened keeps people honest. We had one, as Takura said, they know they're using videotape or body camera, yet the reports are still, deceptive about what really happened. We had believed in one situation that the police went in to a house before the search warrant was signed. And then, we interviewed neighbors and it really looked that way. Ultimately, when we got the body camera, the police officer had said they were the first ones in the house. When you watch it, so it's the body camera, so you see them watch in, you see these police officers in the house walking by, carrying out these big marijuana plants. He clearly couldn't have been the first one in the house. They'd already searched the house and were pulling out marijuana. And there was a big clock on the wall, which, just for that added emphasis, told you what time it was, which was before the search warrant was signed. And then the timestamp on the video was before the search warrant was signed. The officer still testified he was the first one in the house when we played this video and said, that's impossible, right? He just kept saying, I stand by my testimony. And the case was dismissed. But you're right. Eyewitness testimony is so rife with infallibility, and people get it wrong and they think they can identify someone and they can't. But the audio and video is great for everybody, right? I mean, it's great to keep the police in check. It's also great, for the police in terms of no one can say they did something wrong that they didn't do.
So what are some of the other police reform bills that are pending?
One of them is the no knock and then the knock and enter aspect of legislation. One of them would address that aspect. So essentially the police right now, with no knock, I mean, that's exactly what it says. No knock, you don't have to knock. Imagine sitting in your house, police just bust in, whether or not they get the wrong house, whether or not they, the person's really in there, they just bust into your house. Knock and enter is they knock, but then they have to give you time to come to the door. How much time do they usually give people after the knock? Right. Usually it's knock, knock, and then they bust in. There's not like a time frame that is across the board where people are waiting. So it addresses that aspect of very dangerous police practices.
And I think, the Breonna Taylor case is a prime example of why those no knock warrants or knock and enter warrants are not good for people.
And I'll tell you, often my neighbor gets my mail, and fortunately we're on good terms. Oh, hey, I got your mail. Sometimes they bring mine over. Now if they're serving that at the wrong place, I can tell you, if somebody comes into my home at 2-3 in the morning, there's not much conversation that's going to be happening, and you may be seeing me on TV, but it'd be for a different reason. But yeah, they have to give people enough time, and they often get it wrong. This unfortunately was not an anomaly for Breonna Taylor and her family. May she rest in peace. But it has to stop. It has to stop.
Anyone with a firearm if you're sitting in your house or sleeping and your door busts open, anyone with a firearm is going to go for a firearm, or somebody's going to try and flee because you think it's a home invasion, or, you're going to try and defend yourself or your family. And in a lot of those cases, the dogs start going crazy because someone's in the house and then they end up shooting the dog who's not doing anything other than in its own house trying to defend the people there. I mean, it's not safe, not just for the people who live in the house, but the police. I mean, I think legislation on this is so important.
So what are some of the other reforms being proposed?
So, excuse me, others would ban chokeholds unless somebody's life is at risk. Now, we'll see where that goes, because that's a slippery slope. But I think instead of being the go-to way to restrain somebody or subdue somebody, it'll become less and less frequent. So that's one of the many others.
And then some of the others examine the use of force in general, not just with chokeholds, but is there going to be a continuum? Do you try and de-escalate before you go to that use of force where, you can possibly kill someone? And then looking at how you can recruit and then, maintain law enforcement officers. Police get paid. I mean, in a lot of police officers, not a lot of money. We've represented a lot of police officers. We've discussed these cases on our podcast called Constitutional Defenders, and they don't get paid a lot of money. So a lot of really talented police officers will go, because they just pursue another career. They just can't, support their families. They have to work a second job. They'll go work in the private industry. How do you maintain quality individuals? I think salary is one, and training, and continuing education is really important to make sure that the police are not at odds with the community. The police are part of the community, and they're there to serve the community, not to be at odds with them.
Great, Mary Takura, thank you so much.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC. In the Name of Family Law.
Today's family law segment is covering legal custody. What is it really all about? And today we have with us Brandy Thompson, who's an attorney at the Kronzek law firm in Lansing. Welcome, Brandy.
Good morning.
So tell us, what is the difference between physical and legal custody?
Yes, Lisa, a lot of clients that we receive calls from really don't understand that there is in fact two different types of custody, physical and legal custody. Physical custody is really who has the child or children in their possession at a particular time. Sometimes it's week on, week off, sometimes it's every other weekend, but that's really what we're talking about when we talk about physical custody, is where the child's at. Legal custody is a completely different type of custody, and that is the decision-making custody. That is which parent, or if possibly both parents, need to come together and make the important decisions for the child. We're not talking about everyday type of decisions, what they're going to wear for school and those types of decisions if they're younger. We're talking about big decisions that affect the welfare of the children.
So I hear a lot of judges award joint legal custody. So what are the parents' obligations to each other when they share legal custody?
Yes, Lisa, you're correct. Joint custody is definitely where the courts start, and it's very often joint custody determination when we're talking about legal custody. The types of obligations that you would have if you have joint custody with the other parent is that you need to consult with the other parent when you're talking about major decisions, doctors, medical care, scheduling appointments. You need to let the other parent know. You can't just schedule an appointment and not let the other parent. And if the other parent doesn't come, then you should follow up with them and make sure they understand the results, medications, that type of thing. And then school is another big one. You need to share school information. Sometimes only one parent gets that information when there's a separate household, sometimes by accident. And you just need to make sure that you're working together in the best interest of the child and trying to make those decisions jointly as a unit instead of trying to just make all those decisions unilaterally. You have to work together when there's a joint legal custody relationship.
And so just to clarify, you talked about routine decisions that a parent would make during their parenting time, and then quote unquote important decisions that a legal custodian can make. And if it's a joint legal custodian, they have to share that responsibility. And the big picture for those categories are medical, school, and religion. So let's talk about what happens when the parents can't agree on those important decisions that affect their children.
Yes, unfortunately, sometimes you get to the point where parents just absolutely cannot agree on a specific decision. We'll talk about those types of decisions in a few minutes. But what happens? You've got a few choices. Ideally, you can work together and hash it out. And sometimes it's not just a snap decision, and it might take a little time back and forth with the other parent to come to a decision. If you still can't do that, there's options to mediate. Maybe a third party mediator, someone with independent that can listen to both sides and help you guys reach a decision. And then ultimately, if there's just no other answer, either one of the parties can file a motion and take that particular issue before the judge. And the judge ends up making the decision as to what they feel is the best for your child. This is not ideal because it takes the decision-making authority out of both parents' hands and puts it in the hands of the judge. So if at all possible, parents can make decisions together, that's more ideal than taking it out of their hands and putting it in the hands of the judge.
You make a really good point, Brandy, because when the judge decides what's going to happen to a family, sometimes both parents are unhappy with the decision, because we've seen judges that kind of split the issue down the middle, like pick a school in the middle of where two parents live, and it's inconvenient for everybody. But also a lot of times one parent wins in a big way and the other parent loses in a big way. And then the only remedy at that point is you live with that decision or you appeal it. So let's talk about some of those decisions that the parents are most frequently disagreeing about.
Yes, some of the bigger issues that we are seeing when we receive phone calls from potential clients and certainly clients of our own, one of the big ones is school district. You kind of touched on that a few minutes ago, and that is deciding if the parents live in separate school districts, there's sometimes a decision as to what school district the child goes to. That is a legal custody decision. So if the parents can't agree, there's definitely some back and forth. So that's one of the areas that we frequently litigate, is trying to determine what school district the child will go to. And sometimes it's not just the district, sometimes it's the type of school. If we're talking maybe sometimes a traditional public school, and sometimes one parent would rather homeschool the children. So there's definitely, some disagreements with regard to parents in those types of situations. One big thing, especially with COVID right now, are issue of vaccinations. Obviously, vaccinations have always been around, and that's something that the courts are familiar with and have dealt with. When you have one parent who does not want the children vaccinated and another parent who does, that's sometimes left up to the court. And we're now seeing a little bit of an increase in that due to the COVID vaccine that's available now. And so that's another big area where we're litigating. And one thing that I just will point out, just to kind of circle back to what we were talking about, having the judge make those decisions. Another thing, the judges often have a very short time that they're hearing and discussing these types of decisions with the parents. Maybe they have a half hour where they're hearing both sides, and then the judge is making the decision. So that's another thing to keep in mind for these parents that are putting it in the hands of the judge, is they're getting a very, very short snippet of both parents' side, and then making that decision for the family that could potentially have very long-term consequences.
Yeah, absolutely. So how does a parent change legal custody if they're not happy with whatever that legal custody arrangement is?
So it's actually very similar when you're looking at a change of legal custody. A change of custody for either physical or legal has the same avenue. You would file a motion with the court. You're going to have to show a proper cause or change of circumstance in order to get the court to look at whether or not it's then in the best interests of changing legal custody. The court's going to have to make that finding ultimately by clear and convincing evidence, which is a very, very high standard. It's the highest standard we have in the civil courts. And then the judge is going to have to make very specific findings on why they are modifying or not modifying the custody. Some of the ways that I've seen that legal custody the judge would consider is if the parents cannot make decisions together in the best interest of the child. This is more than just disagreeing. This is that they cannot come together and make decisions for the children. Sometimes you got one parent that just lacks the ability to make proper decisions. Maybe they have an addiction or something along those lines where they're just incapable of working and making those decisions. And then sometimes you also have an issue with unequal bargaining power, domestic violence situation where it's just impossible to make a decision together jointly as a unit.
Thank you, Brandy. I mean, obviously, I think that the takeaway is that it's better for the children if the parents can manage to get along. We don't want judges deciding these things, but obviously attorneys exist, and we do help our clients many, many times, like you said, Brandy, with legal custody issues that come up a lot. So thank you so much for helping us understand the important role of legal custody in the lives of the family.
Thank you.
In the Name of CPS Defense and Family Law is brought to you by the Kronzek firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
In 2019, the Michigan no-fault insurance law was drastically changed in many ways. Some of those changes took effect at different times. Some of them just went into effect on July 2, 2021. We have Steve Sinas here from the Sinas Dramis law firm to talk to us about where things stand now. Steve, it's great to have you on the show.
Thank you very much for having me. It's great to be here.
Okay, Steve, so what were the changes that went into effect on July 2nd, 2021?
All right, so the Michigan no-fault insurance law has always been complicated. After these reforms, it's become even more complicated. And one of the things that's hard to understand is all these different ways in which it's been changed and when those changes go into effect. And what we have here on July 2nd, 2021 is a date that marks the beginning of the new rules regarding how insurance companies must pay for the care and treatment for people who've been injured in an auto accident. Let me quickly explain. Under the old law, prior to the reforms, insurance companies had to pay for people's medical services related to their auto injuries, they had to pay their providers a reasonable charge. So the providers had to submit their bill, and the insurance companies only had to pay an amount that constituted a reasonable charge. Now, as of July 2nd, 2021, the rules have changed in a very significant way. It's no longer about the insurance company having to pay a reasonable charge. There's a cap on the amount they have to pay. And that cap it can be complicated in terms of exactly how it is calculated and how it applies to every single medical provider. But suffice to say that for many medical providers, especially those who are providing post-acute care and rehabilitative services to the most catastrophically injured, they're being told that they can receive no more than 55% of their charges that were in effect on January 1st, 2019. So if a person's injured in an auto accident and they go treat with one of these providers, the bill gets submitted to the insurance company. And now what the insurance company is able to do is say, okay, we can demand what your charges were on January 1st, 2019 for those services, and now pay you only 55% of what your charges were back then. And many medical
economic impact.
It's a huge economic impact. And so medical providers are really fearing their ability to stay afloat under these new rules. There are a lot of medical providers here in Michigan that have specialized in treating auto accident survivors under the no-fault insurance system. They've developed their business around their rates of reimbursement, and now they're being told that they have to operate receiving 45% less from the insurance companies going forward. So it's a huge impact on the providers, and in turn, it's a huge impact on the patients, because without their providers, they don't get the care they need. So the reduced rates of reimbursement are a huge controversial issue. And there's a lot of efforts underway to try to hopefully bring about some change to that drastic reduced reimbursement rate. But right now, it hasn't actually materialized in the way we hoped it would.
Well, two questions. One, I heard that some of the providers are having to close their businesses because they can't afford to operate. Is that true?
Yes, I know of several businesses that have decided to close their doors because the prospect of having to operate and receive 45% less was a one-way ticket to becoming a bankrupt company. So they just decided to close their businesses. Many more are fearful that they will. And if I may, what was your other question, Lisa?
Well, you mentioned that there are some possible fixes in the work, but I would really like for you to expand on, what's going on to fix this issue that we have right now.
Yeah, so over the spring, everyone realized what was about to happen, and especially those who were concerned about the needs of the most catastrophically injured. They realized soon we're all going to be operating under these reduced reimbursement rates. It's really going to jeopardize the care and treatment that these people need. And so a group of people that was connected really through social media to begin with, in a group called We Can't Wait, banded together, and they tried their darndest to make a difference down at the Capitol and tried to make sure that these legislators knew what was coming down the road here. And unfortunately, even though they had such valiant efforts to try to bring about change, that change has not come about as we sit here today. But they continue to try, and hopefully the legislature will realize that they do need to make an adjustment here. But it hasn't happened yet.
Now, I heard, Steve, isn't there a large group of former and current Republican and Democratic legislators who were involved with this that are now saying that we didn't really mean for this piece of it to work like this?
Well, and that's what the public should understand, is that these reforms are passed, and I'm not trying to question the intent of people who voted for them, but many of the people who voted for these reforms back in 2019 are coming out and saying, this is not the result we were looking for. And if I may shift gears to another aspect of this, these are new rules that are intended to apply to people going forward, that's for sure. But the other thing the insurance companies are saying is that these are new rules they can apply to people already in the system.
Meaning
so a lot of
people who were catastrophically injured 5, 10, 20 years ago.
Yes.
Right, that had been diagnosed ages ago that they need 24/7 care. Now we have new rules affecting them.
Right. And so you have the thousands of people who have unfortunately been catastrophically injured in auto accidents many years ago, receiving benefits under the old rules, relying upon those old rules as really their rights under the law. And they develop care plans around those rights. And now they're being told that everything's been changed for them, even though they bought their policies back under the old law, even though their premium dollars were based on the old rules applying and not the new rules. And so this has been another huge point of controversy. And this is what you hear a lot of the legislators coming forward saying, that they didn't intend for these new rules to apply to people who are already receiving their benefits under the old law. And that's where there's a big fight brewing in the courts. And actually our firm has a lawsuit at the Court of Appeals right now challenging this idea that you can retroactively apply the new rules to people who are already receiving benefits under the old law. And we'll have to see what the appellate court does with that.
Another problem that you raised with it being applied retroactively, are there any, other than the court cases, or anything else being done to fix that problem?
Well, right now, the court cases are the main hope that the appellate courts will realize and recognize that when people buy their insurance contracts, which is what they are, your insurance contract with your insurance company, that your rights are determined based on what that contract said at that time and can't be rewritten by the legislature years later. We hope that the courts will recognize that. There are ways in which the legislature could act here, but they haven't done so. And so, we're in a very uncertain time here with regard to how this law operates. And that's what a lot of this controversy is about.
Now, I think there were some other significant changes that went into effect on July 2nd. Other than, I think we talked about 2 so far. Were there any other changes you can tell us about?
Well, there was the reduced rate to medical providers, and then there's this right that people have had to have their insurance companies pay for their nursing care at home, their need for assistance and supervision in their own house. And many people have made arrangements with their family members and friends to provide that care, and their insurance companies have had to pay for that. Now there's this new rule under the new law that says that if you receive that care from a person who's a family member or a friend or any type of acquaintance of yours, that the insurance company doesn't have to pay for any more than 56 hours a week of care provided by that group of people. It's a bit arbitrary rule. Why do people need to turn to strangers to provide care when they can rely on family members and friends? So it's another point of great controversy. And again, the insurance companies are taking the position that this new rule applies to people who are receiving benefits under the old law. So I've talked to people across the state being told that their arrangements with their family members and friends to provide care are now going to be changed under this new rule, and the insurance company is going to limit payment to 56 hours a week.
So do you have any further thoughts to share with us about where things stand with the no-fault reform system?
I just think we're at a point of great uncertainty due to a lot of things we talked about here today. And I think the system is now more confusing and complicated than ever. And it's no longer about providing lifetime care to people. You can still get lifetime coverage if you buy it, but so many people are going to be without that. And even if you buy it, the system is now so changed that it's a shell of its former self. And I personally find it to be unfortunate.
Well, thank you for shedding some light on these issues for us.
Thank you for having me.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.
Thank you for joining us for this very informative episode of In the Name of the Law. We look forward to seeing you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.